supposed to operate. And he's joined us on the line. Spent okay. Sometimes I still make that mistake. 16 years in Parliament, right?
Yes.
Yeah, great. So 4 terms in Parliament. Thank you very much for joining us once again, and good morning to you.
Good morning. How are you, Sana?
I am doing. I hope you are too.
You can't complain.
Now, but before I move to the vetting, one thing that came up, and we're just discussing this matter of oral. One thing that came up conspicuously yesterday was Alexander Afenyo's insistence on the fact that the oral preparatory team is an illegal entity. Even he said the entire oral is illegal. What do you think? Do you agree with him?
I don't know. I don't know what he means by illegal. Oral is a creation of a platform, a structure within the administration of John Dramani Mahama for people who have evidence or information concerning others who have done wrong to this country in terms of looting the assets of the state, can report, and that platform takes the reports, do some preliminary investigation, and then forward a docket of what they have found out to the appropriate authorities, in this case, the Attorney General's office, for further study and action. How can that be illegal? Sana, you are a private citizen of this country. If you have reasons to believe that a member of the former government or a member of the present government has engaged in activities that clearly are contrary to the express values of the state, don't you have a responsibility to report? Don't you? Are you a structure? Are you not a citizen? So I don't know what I think that the oral thing has frightened them out of their wits. They are failing to see that this is just a structure, a platform that will allow citizens who otherwise might not feel confident and comfortable in reporting acts of malfeasance and impropriety to the police to come forward before this body and report. That body takes no final decision. It is just an evidence-gathering institution, an evidence-gathering platform. How can that be illegal?
Because he kept raising it yesterday, and you're saying he was doing that because I suppose the fact that there's fear.
Oh, you see, if you know Afenyo Markin, you know why he's raising it before a committee and not court. Because Afenyo Markin is a person who believes that every matter in this country must be resolved through the court system. I'm sure right now he has been in court.
That if he was convinced about what he was saying, yes, he would have been in court.
He would have been in court.
I see. Very interesting. And let's stay on him, because and I'm sure you watched the vetting yesterday. There are concerns that, one, he was unnecessarily disruptive. There are also concerns that it's as if until he is done, the work of the committee is not done. Whilst every member of the committee is actually restricted, he cannot be restricted, and he does not restrict himself. He uses to grab attention unnecessarily. Are these concerns that are genuine,
a bill passed by the House to the President?
This kind of committee.
Ghanaians are in to do.
Yes, they're very, very genuine.
Honourable members, as is stated in the case of Boyfio versus NTAC, that in all these matters, it is the substance that matters.
that has been given to him by the people of this country?
What I can say is that
because
we need to
urgently
go back to the drawing board to see refinance.
The distinction between the 1969 Constitution
currently
and the 1979 Constitution and the 1992 Constitution. In the 1969 Constitution, a person could only qualify to be minister if that person was a member of parliament. So when you look at the 1969 Constitution, there was no requirement of vetting. Nobody vetted the president's nominee for ministerial position because the person would have otherwise qualified to be a member of parliament. In terms of Article 78 and I think Article 93. So there was no vetting. 1979, we went presidential system of government. So members of parliament were not qualified to be ministers of state. And that's why the criteria for the selection of a minister of state is that the person must be qualified to be a member of parliament. The qualification or eligibility for a member of parliament is provided in the Constitution. Is he a registered voter? Has he been convicted of a crime of dishonesty? Has he been convicted of a crime and sentenced to death? Is he a certified bankrupt? The conditions are there. Now, so because we went fully presidential system of government, all ministers of state have to go through parliamentary vetting. That is why the phrase "with the prior approval of parliament" entered our lexicon. 1979. Then 1992, we decided to fuse these two systems, the parliamentary system and the presidential system. And that's why the Constitution provides that he must be a member of parliament or qualified to be a member of parliament. That is bringing the 1969 and the 1979 experiences together and establishing a hybrid system of government, Article 78(1). So I have said repeatedly that if Parliament wants to vet and vet outside the requirements of the Constitution, then they must promulgate regulations. The power of Parliament to vet ministers of state must not be at large. That's my view. And I believe that view is consistent with the rule of law.
The power of Parliament to vet ministers of state must not be at large. Explain that.
At large.
Kindly explain that.
Acts of anything. Anything. So, Afenyo Markin, what was it? It was even action of policy. Policy is within the domain of the executive. Article 58 of the Constitution vests executive authority in the president. Article 298 of the Constitution defines executive authority to be coterminous with the power with which government acts. So, president is government. If you read Article 58 and Article 296 together. So why will you ask somebody whether a policy of this will be implemented? That decision rests with the president, executive authority. So you see at large, when that person you are asking is holding that position at the pleasure of the president. So he was asking For instance, in the case of Afenyo Atu, he was asking him questions as if Atu is the president of the Republic of Ghana. But read the Constitution and Cabinet. It is to assist the president. It doesn't supplant the power of the president in policy formulation. Assist the president. So that's why I think that we are abusing the office. So is that person. So that's why the timely reminder of Afenyo Markin of the provisions of the Constitution, which says that the person must otherwise be qualified as a member of Parliament, was very apt. That was intended to draw his attention back to what the vetting process is about. So in my view, we have mixed two processes and have allowed Parliament to run wild with the vetting process, and particularly this Parliament.
I see. And particularly because there was a concern about the fact that there was a convention in Parliament that says that leaders of Parliament must be vetted in a different manner. And you had the minority leaders sitting there for over 4 hours. Was that consistent with that convention?
Right. Well, first of all, it's a convention. I didn't believe in that convention. There was no need, actually, unless there were issues of the eligibility of the former minority leader in holding office as Minister of State. Nobody has asked you to test the competence of that person. Nobody. The Constitution doesn't ask. It's a political decision, law. An appointment of a Minister of State is a political decision. Your right to challenge that appointment should be founded in law. You should be able to say that that person is otherwise not qualified in terms of the law to be a minister. But if the president appoints a person into a ministerial position, which person in Twi, I heard you were speaking to this morning, is a person who is born, or born. The judgment on that person is a political judgment. And that will reflect on the government.
Are you saying where Parliament finds, based on his questioning, that person perhaps is not hearing suited for the position? The Parliament
Nobody has said Parliament has the power to determine the competence of a person to hold a position.
Then exactly what is vetting supposed to do?
Vetting is supposed. I've given you the historical antecedents of vetting in this country. I've told you this morning that in the 1969 Constitution, because ministers of state came from Parliament, there was no vetting. Because the person who was in Parliament was otherwise qualified to be a Minister of State. So why vetting? And I've told you that in 1979, there was vetting because a member of Parliament could not become a minister. So Parliament needed to satisfy itself that person who was otherwise nominated to be minister was otherwise qualified to be a member of Parliament. That's the highest standard. And the eligibility of a member of Parliament in the 1992 Constitution is provided. So has that person met that criteria? Is he a registered voter? Is he a citizen of this country? Does he owe allegiance to another country? I've told you that. So you want to know whether that person can be a member of Parliament. That is the vetting. In reading the Constitution, I don't see anywhere that the Constitution says Parliament should test the competence of that person or the understanding of that person of governance. I don't see it anywhere.
But Alaji, if we go by what you're saying, virtually every person who a president nominates will usually go through, because we've seen people in parliament.
No, not virtually everybody. Is that person qualified to be a member of parliament? Has he registered as a voter, Scipio Gabra? Has he done his national service? Does he owe allegiance to another country? Is he a certified bankrupt? Has he been convicted of a crime of dishonesty? So even parliament, that's why there are some people in parliament today, they can't be nominated as ministers because they have been convicted of crimes of dishonesty and they're sitting in parliament.
I see.
That is the vetting law. And you remember, in Ghana here, they don't want the truth. When you say the truth, they say, bring your head and they'll cut. When Akufo-Addo nominated his ministers and they were vetting them, and I said it will surprise me if they disqualify anybody. They said I should bring my head and they'll cut. Because almost all of them at that point were members of parliament. And my understanding of constitutional law and the requirement of vetting and how we moved from no vetting to vetting clearly informed me that members of parliament can spoil. In vetting, they can expose the inadequacies of a ministerial nominee. But it will be gross injustice to disqualify somebody on the basis of a subjective assessment of competence.
Alaji, do you share the concerns of those who think that the chairman needs to take a lot more control over the proceedings?
Hey, you didn't see the control. The chairman is not a duck. He doesn't quack. He sits quietly and observes the situation and then intervenes when it is appropriate. What I think should happen is that the members of the House, of the vetting committee, must checkmate Afenyo Markin.
They must checkmate him.
They must checkmate him.
Like the way Honorable Goja I was doing yesterday?
Yeah, like relevance. And the question of relevance.
I see. Honorable, thank you very much for speaking to us this morning.
You're welcome.
That's the Honorable, that's Alaji Inusah Fuseini. SM do that business, we'll take a break when we'll come back.
PC Heba, Mami Zima Honiakui, air menstrual pains, poor flu, waist and back pains, and I say, Oya Bema, or performance, above from poor vision infections. Call PC Heba.